Two copyright cases have now found that training artificial intelligence large language models on copyrighted data is not necessarily copyright infringement. I'm Professor Laser. Let's walk through it. One of these cases found that training AI models is a transformative use that constitutes fair use under the Copyright Act. Another decision finds that it will often not be fair use, and it was simply that the plaintiffs in that case failed to adequately present evidence of market harm necessary to prove copyright infringement. These cases come out very differently, however, on whether it's okay to use pirated works to train these models, with one decision finding that although the use for training the AI model was okay, obtaining pirated works, downloading them, was not okay and constituted copyright infringement. Whereas in the other case, the court held that using pirated works does not constitute copyright infringement at any level because the ultimate purpose of obtaining the pirated copies was for training an AI model, which was fair use. We'll have to see how other courts come out on these issues as many of the other AI copyright cases continue to develop. These are very different approaches that will lead to dramatically different results in future cases. I'm going to walk through each of these two opinions. The first case that I want to talk about is Bartz versus Anthropic. This is a summary judgment opinion that was handed down by Judge Alsup. Now, Judge Alsup has a lot of experience with technology matters and is a judge that often digs in deeply to the technology issues in the cases before him. He was a math major and is one of very few judges who have STEM experience. If you want to know more about the amount of STEM experience that we have in the federal judiciary, check out my recent article, which is available for free at SSRN. The Bartz versus Anthropic case. In this case, Judge Alsup found that it was not an infringement to train a generative AI system on lawfully obtained copyrighted works. Let's walk through the opinion. The court found that Anthropic's use of lawfully obtained copyrighted data was permitted and was a transformative fair use for purposes of creating a generative AI system. However, the court found that Anthropic's use of pirated works was itself a copyright infringement, and that AI companies should not be obtaining or storing pirated copies of copyrighted works in order to assist their development. As some factual background, it was important to note that many of the initial digital books that were obtained by Anthropic were obtained from pirated websites and not purchased by Anthropic through any lawful means. This is important as we get further on into the decision. Then they ended up hiring someone who was involved in Google Books, and that person started trying to work with publishers to obtain lawful copies, but ended up dropping that project. Instead, it decided to purchase physical books. Now, these were lawfully obtained physical books that they then digitized. And as we'll see as we get further along in the case, that digitization step of lawfully purchased books was actually an okay fair use in this case. But ultimately, their data set ended up including both digital copies of lawfully purchased books as well as unlawful pirated copies. Anthropic also kept those unlawful pirated copies in a central repository after it was completed training. The court points out that Anthropic used these books because they needed creative works in order to generate high-quality outputs for their generative AI models. And it was also important that, unlike in cases like New York Times, you would not get an output from the Claude service that matches the inputs that are alleged to be infringing. This was really important. And that's simply not an allegation that the plaintiffs made in this case here. This is different from New York Times, where New York Times has made the allegation that you can obtain copies of New York Times articles from the outputs that are produced by the generative AI system. Here, the court decides that there's not this risk that the copyrighted works are going to show up in the output. They're saying that Claude put guardrails on its system to prevent its outputs from matching the inputs that were put into the system. This is important because that's a totally other way to find copyright infringement if the output matches or is substantially similar to the input. But that wasn't happening here. It was not alleged here, at least. So now we have this summary judgment by Anthropic. They're trying to say that their actions are fair use and therefore do not violate the Copyright Act. There's also a class action that could happen here. There's a potential for plaintiffs to obtain class certification, which means that many people can participate in the lawsuit and collect damages if there is a finding of infringement or a damages award here. Now, the court decided to wait to decide the issue of class certification, meaning how many people are going to be part of this class and what do they look like. That's going to happen after we get through this process of summary judgment. The court undergoes a traditional fair use analysis, which is set out in the statute, Section 107 of the Copyright Act. This says that fair use is a multi-factor test that includes analysis of 4 primary factors: the purpose and character of the use. This will consider things like, is it commercial or is it nonprofit? Is it transformative or not? The nature of the copyrighted work, meaning, is this a creative work or is this merely a set of facts or something not entitled to heightened protection? The amount and substantiality of the use, meaning how much of this work is used in the final output and what proportion of the final output is made up of that individual work. And then also the effect of the use. So this looks at the competitive conditions and how the use impacts competition. To start with the purpose and character of the use, the court finds that the purpose and character of using works to train large language models was transformative. The court says it's spectacularly so. And in part, this is because the court views generative AI systems as being very different from the experience of reading a book and from what authors might want people to get when they read their original works. This is not for purposes of education or entertainment necessarily from that book, but is for the purposes of generating new written text. The court says that it's fundamentally transformative to take something that was written as a book and then think about it, digest it, and convert it to something else. Both the authors that were suing here and Anthropic compared it to the situation where if somebody reads a book and then they digest that and spit it out, does that make it an infringement if somebody reads a text and then writes a new text? The court says no. You may need to pay for getting your hands on the original text, but what you learn in your lifetime and then regurgitate out in the form of something new and your own is not an infringement. And likewise, the court says that this is similar to what an AI system is doing in this context. It also distinguishes previous cases that have found there to not be a fair use. In those situations, they were not generating new content and they were more closely competing with the original. So the Thomson Reuters case, for example, was very different, the court found. However, the court says that although use of copyrighted materials for training an AI system favors a fair use finding, the analysis is very different for the creation of a central library that Anthropic maintained of all of the books and components that were used in its training sets. There are 2 sets of considerations that the court takes in turn. First, the court finds that copies that were purchased, physical copies that were purchased and converted from print to digital, are lawful, that this is a fair use, and it was totally appropriate to convert something from physical to digital form, that itself does not constitute a copyright infringement, because that is transforming the original work and does not compete with the original, especially because here Anthropic destroyed the physical copies. And it compares it to a number of other cases, like in Google Books, where the court finds that this print to digital conversion is transformative. It is important, however, the court notes that there's an expectation that those copies are not going to be distributed to others. It's only going to be used for maintaining that repository. Next, we get to another issue of pirated copies. The court finds against Anthropic here, saying you cannot justify pirating books or making copies of books without obtaining them lawfully if an AI company admits, as Anthropic did here, to pirating millions of books. That is not going to be considered a fair use to copyright infringement merely because the purpose of pirating all those books was to eventually use it for training an LLM. The court says that it is not appropriate for these AI companies to download any content illegally, and that instead they should be purchasing lawful copies of works in order to train them. It says, in theory, Anthropic argues it could have done as Google did in Google Books by finding a reference library willing to loan copies for free, or it could have gone to buy copies. But the court points out that's not what Anthropic did for the portion of the data set that was obtained from pirated copies, and that is not okay and does not constitute fair use. The court also considers the other fair use factors, saying that the author's books were chosen for their expressive qualities. This is a consideration that weighs against a finding of fair use. The court also considers the amount and substantiality of the use. Now, here, the court says that there's no allegation of a traceable connection between Claude's outputs and the author's work. So we don't have a situation where, for example, the output is giving us 75% of a book that we would ask for. It's not providing that information to users. Here, the only allegations are that the incremental copies were used for purposes of training a large language model, and that each of them was only one out of many, many books that were used in that training. And everyone agreed that Anthropic needed to use billions of words to train this LLM. This transformative use required the use of many, many books. The court finds, however, that it was not appropriate to pirate books to do so. The court finds that for the pirated copies, Anthropic lacked any entitlement to hold copies of the books at all. So that obviously weighs against fair use for the pirated copies, but the court still finds in favor of fair use for using purchased library copies to train LLMs and for converting purchased library copies to digital. Another factor that the court considers is the effect of the use on the market for the copyrighted work. Now, this is a really interesting consideration because many authors have argued that training LLMs will result in an explosion of works competing with their works. But the court here says that that is not the kind of competition that the Copyright Act is designed to stop. Primarily, the Copyright Act is designed to stop competition of works that are substantially similar, but here, the authors conceded that the training LLMs did not result in exact copies or even infringing knockoffs of their work being provided to the public. And so the court says this is not similar to the type of competition that's protected by the Copyright Act, that simply creating new works is not a violation. The court compares it to a situation where a student is writing some new work because they learned how to write from reading other books, and that the Copyright Act is not designed to stop people from creating new works after having read previous works in order to get a better understanding of grammar and word structure and expression. The court also rejects the author's viewpoint that there is some value in being able to license the work, and that taking this work without getting a specific additional license from the author for training is potentially undermining the author's ability to earn money by licensing their works to other AI models. The court cites some other cases that find that in order to make that kind of argument, the authors would have had to have some specific opportunity to be licensing their works that they would cite. And in this case, those authors had never had the opportunity to license their works to any other AI company for training. Ultimately, the court does find fair use for Anthropic in the case of training a generative AI system using lawfully obtained copyrighted works. However, the court decides to go to trial on the question of whether Anthropic has infringed many copyrighted works by pirating them and maintaining it in their central library. This could potentially result in millions or maybe even billions, depending on how large the class that gets certified ends up being. In this case, many of these books were registered with the Copyright Office, and you might be seeing millions of works that are potentially subjecting Anthropic to statutory damages. Statutory damages apply as a multiple of the number of works infringed. So this is why we saw such high damages, for example, in cases against MP3 file sharing websites and people that downloaded MP3s unlawfully. I think we could be seeing much higher numbers when it comes to the works that were used for training these AI models, to the extent that those works were not lawfully obtained. So ultimately, we'll have to see what happens at trial in the Anthropic case. We also have many other cases that are still pending, and those courts might come out different ways. This is just a trial court decision, and it could also be appealed. I imagine that because of the many different decisions that we're going to see on these issues across the United States in the coming years, that in something like 3 to 10 years, we may get a Supreme Court decision that decides the fate of AI training and copyright infringement. Another recent key case is Kadrey versus Meta, which makes the Llama model. Let's take a look at this recent decision finding summary judgment in favor of Meta on the issue of copyright infringement of use of copyrighted works for generative AI model training. This decision is very different from the decision in the Anthropic case. It's by a different judge, and this judge has very different theories of what could constitute fair use and what could constitute infringement in a copyright case involving generative AI model training. So here, the court ends up deciding on summary judgment that there is a significant risk that generative AI could flood the market with endless amounts of images, songs, articles, books, and more, and that this could compete with the market for the original works in a way that would render the original works to be infringed, and that there would be no fair use. The court says that the performance of a generative AI model depends on the amount of quality and data that it absorbs, and companies have been unable to resist the temptation to feed copyright-protected materials into their model without getting permission from the copyright holders. This court decides to proceed on a slightly different theory than many of the other decisions that we've seen. This court ends up deciding that the company's use of the works to train AI models is fundamentally transformative, and that would favor a fair use finding. However, the court says that transformative use is not the be-all, end-all of the copyright fair use analysis, and rather, the most important factor is actually the competitive nature of the use, whether this is going to undermine the market for the original works. Here, the judge says that they disagree with Judge Alsup and finds that training an AI is not like training a school child. It uses the books in very different ways, and therefore it's not likely to constitute a fair use simply on the basis of being similar to the way that humans ingest works for creating new works. The judge here warns that judges should not find that AI companies are not infringing simply because they worry that copyright infringement lawsuits could stop the development of this new technology and push those companies outside of the United States. The court points out that AI companies stand to make billions or trillions of dollars from this technology, and that therefore it's more likely that these companies will find a way to operate, whether they have to pay copyright creators or not. The court rejects a number of arguments from the authors that would support copyright infringement. The court rejects that Llama is capable of reproducing significant amounts of their books. And the court also rejects and says that the argument is a clear loser, that Meta, by using the author's works for training without permission, has diminished the author's ability to license the works for purposes of training other large language models. However, the court seems to have a strong view that the best winning argument for copyright infringement cases against generative AI companies is that there's a potential for AI-generated works to flood the market and therefore outcompete the original works or other original works. However, the court says that although this argument would carry the day, it does not do so here because the plaintiffs failed to develop that argument during the course of discovery in this case. Under the fair use analysis, the court applies the traditional four-factor test, looking at the purpose and character of the use, the nature of the copyrighted work, how creative is it, and the amount and substantiality of the portion used, and the effect of the use upon the potential market. This fourth factor is what this court focuses on. The court says that the fourth factor is undoubtedly the single most important element of the fair use analysis. The court also says that the defendants, if they were found to be infringing, would simply obtain a license for those infringing works. However, I do want to point out that the potential damages from a copyright case is far more than simply the fair licensing rate, and rather statutory damages would apply in most cases where you're looking at books, because books are typically registered and therefore entitled to statutory damages. The court discusses where Meta ultimately obtained the data that it used for its models for Llama. The Llama models are available for free for non-commercial use for all of the models and for commercial use for the older models. In order to obtain data for use in training the Llama models, Meta looked to publicly available databases, which included both copyrighted and non-copyrighted works. For Books 3 is one of the databases that contained copyrighted material that Meta used for training the Llama model. Meta also tried to negotiate deals with several major publishers, but ultimately decided that it was too logistically challenging to do so because it had trouble coordinating in order to obtain those rights. The rights to use copyrighted data for AI training is often more complicated than simply the right to reproduce, and oftentimes original authors have not granted the right to their publisher to sublicense those rights for transformative uses or derivative uses to their publisher. So instead of using licensed material, Meta decides to use what the court calls a shadow library, where it downloaded something called Library Genesis database, and thereafter it also downloaded Anna's archive, which included LibGen, ZLibrary, and others. Notably, some of these services have been found to be infringing the copyrights of authors that appear in their databases in previous cases. Meta also decided to use BitTorrent to download these databases, and that might have included some instances in which Meta re-uploaded a portion of the data and thereby perpetuated those marketplaces for unlawfully obtained copies of copyrighted works. However, Meta applied guardrails to make sure that the outputs that were generated by users would not be substantially similar to the inputs and would not generate full copies of the books that were used for training. Ultimately, there's been a lot of different causes of actions that were brought up in this case. Many of them were dismissed. A claim under the Digital Millennium Copyright Act remains and is going to be decided in a separate order. This particular order only looks at the cross motions for summary judgment on the issue of copyright infringement and fair use for the training of generative AI models on copyrighted work. The court walks through the four factors of the copyright fair use analysis. To begin with, factor one, the purpose and character of the use. The court finds, as other courts have done, that this use is transformative, finding that creating new, completely different works from the original works is fundamentally a transformation of the purpose of the original works to entertain or to provide information on a specific topic. The court says there's no serious question that Meta's use of the plaintiff's book had a further purpose and different character than the book's. The purpose of Meta's copying was to train LLMs, which are innovative tools that can be used to generate diverse text and perform a wide range of functions. This is something that it seems clear that most courts are deciding is transformative, although I do think that reasonable minds can differ as to whether it's actually transformative. But here the court ends up saying that it is fundamentally transformative to train an LLM in order to produce a generative AI text. The plaintiffs also made an argument that the ability of the LLM to output styles that are similar to their own is problematic, but the court here says that styles are not copyrightable. This is something that's very much up for debate in the current legal academy. One of the considerations for the fair use analysis, factor 1, is whether it's commercial or non-commercial. And the court says that even though Meta makes some of the llama models available for non-commercial and commercial uses by others, that this is fundamentally a commercial enterprise for Meta where it expects to generate revenue, and therefore that aspect would not favor fair use under the first factor. However, the court ultimately finds that this is a transformative enough use that under factor 1, it would favor a fair use. Plaintiffs also make the argument that won the day in the Anthropic case that because Meta acquired the plaintiff's books from pirating websites and did not pay for those copies, that constitutes copyright infringement regardless of the ultimate use of those materials. But the court here finds that downloading pirated material can be fair use if the ultimate purpose of that download is for a use that is itself a fair use, here the training of AI models. This is a big difference from the Judge Alsup opinion in the Anthropic case. These two judges seem to have very different views of whether it's appropriate for a large company to be pirating material and what circumstances they may do so. I think back to all of the folks that were charged with criminal copyright infringement for downloading material from torrent websites and listening to it. It seems to be far less harmful than the scale of the pirating that's happening by these AI companies. The court ultimately finds that it is not necessarily problematic that Meta used pirated copies of copyrighted works for its training, although it finds that it may be relevant to the issue of bad faith, which some courts have considered under the first factor. But the court here finds that here there is not enough evidence of bad faith to justify a different consideration on factor 1. The court even points out that many of these libraries that Meta used have themselves been found liable for infringement, and that some of their operators have been indicted for criminal copyright infringement. Nonetheless, the court here finds that because this pirated data was ultimately used for a transformative purpose and for a purpose that was fair use, that therefore this is not a copyright infringement to download the material for purposes of creating that database. The court also points out that if Meta's active downloading propped up those libraries or perpetuated their activities by generating ad revenue or helping to create more copies that were distributed elsewhere, that could have potentially constituted infringement. But here the court points out that the plaintiffs didn't put any evidence in of that. The court ultimately finds that because Meta's ultimate use of the books was transformative, so too was Meta's downloading of these books. And the downloads the plaintiffs identified had the ultimate purpose of LLM training. Therefore, downloading pirated copies did not constitute copyright infringement under factor 1 of the fair use analysis. The court then looked to factor 2, the nature of the copyrighted works. This one is straightforward. The works that are asserted to be infringed are books, which are classically creative works that are protected by the Copyright Act. Under factor 3, the amount and substantiality of the work, the court finds that this factor favors Meta because even though it copied the books in their entirety, the amount that was copied was reasonable given the need that Meta had for its transformative purpose. So the court said that it was reasonably necessary for Meta to make use of the entirety of the works in order to engage in the transformative use of AI training. Under Factor 4, the effect of the use on the potential market, the court here finds that this is the most important factor and that it believes that in many other situations, that this factor will be dispositive and result in a finding that there is no fair use and that there is copyright infringement, because the court notes that this will result in flooding the marketplace. The court says, given the fourth factor's importance, it's easy to imagine a situation in which a secondary use is highly transformative under Factor 1, but the secondary user nonetheless loses on fair use because allowing people to engage in that kind of use would have too great an effect on the market for the original work. So this is the theory that the judge brings in to its analysis of the market factors, the market effect here. The court points out 3 ways that a plaintiff could try to argue that there's harm to the market by an AI model. So first, plaintiff could claim the model would regurgitate their works, but here that doesn't seem to be happening, or the plaintiffs didn't present evidence of that. Second, plaintiff might point to the market for licensing their works for AI training, but here the court again rejects that, saying that there is no marketplace for that and that that would not be relevant or would be circular. The plaintiffs stated that they would be willing to license their books for use in generative AI training, but Meta did not approach them to do so. None of the plaintiffs have been able to obtain licensing revenue from any other AI company in order to train their models. So this is not something that's an established practice. And then third, this is the one that the court says is going to be very important. Plaintiffs could argue that even if the model can't regurgitate their works or generate substantially similar ones, it can generate works that are similar enough that they will compete with the originals and thereby indirectly substitute for them. So the court says that this third element is far more promising. However, in this case, plaintiffs failed to provide evidence, the court says, that there was in fact market harm from the flooding of marketplaces with AI-generated works. The court seems to suggest that if other plaintiffs bring up enough evidence that shows that there's market harm from generating massive amounts of AI works that are going to flood the marketplace and crowd out original human authorship, that could favor a finding of copyright infringement and weigh against fair use under Factor 4. The court seems to suggest that this third way, that using the LLM to flood the market, is going to be problematic in most cases. One of the experts for plaintiffs briefly notes that AI-generated books are flooding Amazon, but the court says that there isn't enough evidence. That was the only bit of evidence that the plaintiffs put in on that type of market harm because they were focused very much on the question of whether there is a market for licensing their works to LLM models. The court really focuses on this potential harm in the form of indirect substitution rather than direct substitution, meaning that instead of the harm to the marketplace referring to harm from reproductions of substantially similar works, that it would be harms to the marketplace because people would buy other works that are not substantially similar to those works. This is a relatively new way to conceptualize the fourth factor and market harm. The court points out that many law professors disagree that this market delusion theory is appropriate or that it should count as fair use under the fourth factor, but the court points out that there may still be a harm to the market from less similar outputs. And by taking sales from those books or by flooding stores or online marketplaces so that some of those books don't get noticed and purchased, those outputs would reduce the incentive for authors to create, the harm that copyright aims to prevent. So the court explains this theory in a lot more detail. The court ultimately concludes, however, that there is no evidence in this case of market harm. The court seems to chide the plaintiffs for failing to put forward the type of evidence that the judge wanted to see, but I don't blame the plaintiffs for that because it wasn't clear until this decision came out that the court would focus so much attention on that potential theory of market delusion which is not a commonplace theory for consideration of the fourth factor. The court also points out in a footnote that downloading a shadow library or a pirated library would not necessarily constitute copyright infringement if the ultimate purpose of doing so is for a transformative use or a use that doesn't cause market harm. This is very different from the Alsop case, where the court found that downloading pirated copies is an infringement. The court also considers the public interest and says that the public considerations favor Meta, even though it's using copyrighted work. The court finds that where copying LLM training isn't fair use, LLM developers, including Meta, won't need to stop using copyrighted works to train their models. They will need only to pay rights holders for licenses for that training. However, this is not how the marketplace for copyrighted works generally plays out in these scenarios. Ultimately, rights holders currently don't have a marketplace for licensing their works, and the methods of obtaining lawful works, like the ones that Anthropic used of purchasing print books and then digitizing them, is likely the only way that these LLMs are going to obtain copyrighted works lawfully. The only way that there's going to be a marketplace for the rights to the copyrighted data is in these lawsuits, is by copyright holders getting damages from these lawsuits. And those damages are likely to far exceed the amount of a reasonable licensing fee or a likely licensing fee in a hypothetical negotiation. These developers will be paying billions of dollars if they are found to infringe a copyright because of the statutory damages available under the Copyright Act. This is not a situation where the outcome of these lawsuits is going to be a simple or reasonable licensing fee. And therefore, it's disingenuous for the court to say that a decision here won't stop LLM manufacturers from training their models on copyrighted works. It may very well be the case that no marketplace exists for the reasonable license that the court believes will happen here. The court ultimately concludes that in cases like Meta's, plaintiffs will often win when they can develop the record to the issues that mattered to this judge, namely this theory of market delusion. So I think that this is probably not very fair to the plaintiffs here because the court proposes a rather new theory of market harm and then says that the plaintiffs failed to present evidence and discovery in support of that theory. And yet the plaintiffs would have no idea that the judge would be considering that potential theory. So I think that this would be more appropriate for a potential reopening of discovery to consider the matters that are addressed by the court's opinion here. The court said, had the plaintiffs presented any evidence that a jury could use to find in their favor on this issue of market harm, Factor 4 would have needed to go to a jury. So we now have two copyright cases where judges are finding that there is not copyright infringement when AI companies use copyrighted works to train their large language models. These court decisions arrived at that conclusion through very different mechanisms. We see in the Anthropic case that there was a focus more on the transformative nature of AI use. And we see in the case with Meta that the court focused on the lack of evidence presented by the plaintiffs to support a new theory of market harm that would apply under the fourth factor. So it's likely that the judge that decided the Meta case would find that other future cases are in fact copyright infringement and not fair use, whereas judges like Judge Alsop are going to continue to find that there is fair use due to the transformative nature. In the Anthropic case, we see that the judge has no tolerance for piracy in obtaining the copies used for AI training, and the judge finds those to be separate instances of infringement, ding the defendants in that case to billions of dollars of damages, or at least millions of statutory damages, depending on the size of the class. The judges have dramatically different views of why and whether use of copyrighted works for the training of AI models would constitute infringement or fair use. We'll have to wait to see how these various AI cases play out on appeal.